Well, good morning, everyone. I'm honored to be here today with such a great, passionate group of speakers. That's on, right? And they've been fighting the fight for decades. I'm going to talk a little bit, as Allison said, about the litigation. Mr. Jocks talked about it a little bit earlier this morning. I'm going to kind of do a deep dive. Since the title of the presentation is I think it's Advancing Solutions, I thought I'd focus on what the religious claims have been throughout these cases and how they've sort of evolved over time, what we're looking at today currently, and what we might be looking at in the future in terms of religious claims. I should say my name, right? I'm Laura Berglan. I'm an attorney with Earth Justice with the Tribal Partnerships Program. I'm located in Tucson, Arizona. I am associated with the Denver Earth Justice Office, and we represent tribes and indigenous community groups in environmental litigation and environmental justice litigation. Let's see. Ooh, we've got transitions. All right, so it's been said that the lack of federal protection for tribal sacred sites is really the most glaring loophole in federal Indian law, and I think you'll see that as this presentation walks through both the cases that involve Snowball and then other cases that involve sacred sites. So what I'm going to do is walk through primarily the two substantive cases involving Snowball, that's Wilson versus Block and Navajo Nation versus U.S. Forest Service, and then walk through some of the changes in law that's happened during that time, as well as a sort of additional case law that's happened during that time as well. So Mr. Jocks kind of touched on this earlier, so I don't need to spend too much time on it. But this was back in 1977, the Forest Service transferred the permit to operate the ski resort to Northland Recreation, and Northland proposed a larger commercial undertaking, excuse me, so a master development plan that would expand the facility, new chairlifts, et cetera, kind of turning into a commercial ski resort, whether before it was a pretty small facility. So we're talking about 120 acres for new ski runs, new lodge parking lots, et cetera. So in 1980, after the NEPA process took place, the Forest Service selected the preferred alternative. So during that same period of time, Congress passed what's called the American Indian Religious Freedom Act. ARFA is how I'll refer to that, and that was in 1978. And they were attempting to address this sort of history of religious persecution and the continuing pattern of government action that's impeding Native American religious practices on federal lands. So with ARFA, Congress had recognized that the federal laws governing public lands had long ignored the impacts on Native religious practices. So it was sought to remedy those failures through this explicit commitment you see in the policy here on the screen. It shall be the policy of the United States to protect and preserve for American Indians their inherent right to freedom to believe, express, and exercise the traditional religions of the Native American groups, including but not limited to sacred sites. Great, we've got something we can hang our hat on here, something we might be able to litigate with moving forward. But not so much. The Supreme Court then subsequently held that ARFA does not create a judicially enforceable cause of action. So you'll see in the Block case then that wasn't successful, and in other cases moving forward, that ARFA does not provide a cause of action for tribes. It's just sort of nice policy. And I think this was mentioned as well, Executive Order, for example, 13007 about sacred sites is the same thing. It's a nice policy, but it's not giving tribes an opportunity to litigate those claims. So primarily what tribes have been relying on would be the free exercise clause of the First Amendment, and that was in Wilson versus Block, and a law that's passed further down the line, RFRA, Religious Freedom Restoration Act, and that was relied on in Navajo Nation versus U.S. Forest Service. So we'll jump right into Wilson versus Block. All right. So this was in 1981. As Mr. Jocks mentioned, the Navajo Medicine Men's Association filed suit. The Hopi tribe and two individual ranchers, Gene and Richard Wilson, also filed suit. Those cases were all consolidated together. The tribal plaintiffs in that case were arguing that the operation and expansion of Snowball constituted a violation of their First Amendment right to free exercise of religion, due to, again, to the sacred nature of the peaks and the centrality of the peaks to their respective religions. In addition, the tribal plaintiffs were also trying to remove the facilities as well. So stop additional expansion and then additionally remove the facilities that were there, again, based on their First Amendment free exercise right. Other claims were made as well. Again, we're going to be focusing on the religious free exercise of religious claims, but the other claims were made were ERFA. As we said earlier, that claim wasn't successful because it doesn't provide a cause of action, a legal hook, in other words, for the tribal groups. The National Environmental Policy Act, claims were made under that, the Endangered Species Act, the Wilderness Act, the Multiple Use Sustained Yield Act, and the National Historic Preservation Act. The tribes also alleged breach of trust based on the federal government approving the issuance of the permits. So driving into the actual violations of the First Amendment rights. So the actual language in the First Amendment reads that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So in these free exercise claims, we focus in on that last provision, prohibiting the free exercise thereof. And the crucial part of that free exercise clause is the word prohibit. So the clause is stating what the government cannot do, prohibit the free exercise of religion, but does not set forth what an individual might exact from the government. So in this case, the court held that plaintiffs seeking to restrict government land use in the name of religious freedom must, at a minimum, demonstrate that the government's proposed land use would impair a religious practice that could not be performed at any other site. So we're going to hear this same language kind of throughout this string of cases that we're going to be going through. So a prohibition on practicing the religion at that particular site. The court also further reasoned in that case that the tribes could still conduct their religious ceremonies at other sites on the mountain, and noted that the Snowball area itself comprised 777 acres of the 75,000 acres of the peaks, and that they've already coexisted, the tribes and the resort had already coexisted for nearly 50 years. And the court then finally held that the plaintiffs weren't able to demonstrate that the development of Snowball would prevent the tribes from practicing their religious ceremonies. So, we'll move along. About other developments kind of in the interim. So the rest of the claims failed as well, I should say. And so that was the state of the law. Then we've got some developments that occurred between Wilson versus Block and Navajo Nation versus U.S. Forest Service. First of all, and Mr. Jocks mentioned this one already, Ling versus Northwest Indian Cemetery Protective Association. That case came down in 1988 from the Supreme Court. This is another free exercise of religion First Amendment claim. This case was 3 tribal members challenging the Forest Service's plans to permit timber harvesting and road construction in areas of the National Forest that were traditionally used for religious purposes, and this was in Northwest California. The court in that case held that the free exercise clause did not prohibit the government from prohibiting the timber harvesting and the road construction in the areas of questions that the tribes were not coerced, here's that word again, by the government's actions into violating their beliefs. So again, we're in that language of coercion, prohibit, those are the terms of art here that we're looking at. So another development in the interim, and I think Mr. Jocks mentioned this as well, is Employment Division versus Smith. So that case wasn't a sacred sites case, but it was an unemployment benefits case for members of the Native American Church that had been fired for violating a state prohibition on the use of peyote, and they weren't entitled to unemployment benefits as a result, even though peyote is a part of their religious beliefs as a part of the Native American Church. So this, again, is a Supreme Court case. And the court, in a really kind of drastic move at that point, held that generally applicable laws not targeting a specific religious practice do not violate the free exercise clause and are not subject to strict scrutiny. So we'll talk about a little bit later the substantial burden test, and then we turn over into strict scrutiny of those laws. Now, what the court is holding is basically any law is fine. If it's a neutral law that applies to anyone, even if it effectively prohibits the practice of your religion, that's not going to violate the First Amendment. That's basically where we're at with Employment Division versus Smith. So, what happened in response to Smith is that Congress enacted the Religious Freedom Restoration Act in 1993. And Congress said, court, you've gone too far here. We want to put back in the compelling interest test, so any government action that that substantially burdens the free exercise of religion needs to have a compelling interest. Excuse me. So we want to reenact that test, which is set out in a Supreme Court case called Sherbert versus Verner, and we want to put that back in and make that be able to be a defense for anyone that's having their religion substantially burdened. So it's going to substantially prevent the government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability, unless the government can show that the burden furthers a compelling government interest and does so by the least restrictive means. Thank you. So basically, the RFRA test that's created by this law is as follows. The plaintiffs first are going to have to prove a substantial burden to their religion. So that's their burden when they bring a case. That's the first step. If they go over that hurdle, they show a substantial burden to their religion, then the second hurdle then passes to the government. The government then has to prove that that they have a compelling interest in whatever action they're doing, and they're using the least restrictive means. So this first hurdle is always the toughest one, getting over that substantial burden, and that's what we're going to talk about in the next few sacred site cases. So first up, Navajo Nation versus U.S. Forest Service. Oh, sorry. Missed a slide. Okay. So in 2002, the Forest Service puts out a scoping notice for more development at Snowbowl. The biggest concerning piece of that is the making snow with reclaimed water, and that would be on approximately 205 acres of the resort. It's a number of other expansion projects as well, additional lifts, chair lifts and surface lifts, new skiing terrain, and a snow play tubing area, a new parking lot, and some other infrastructure improvements. That preferred alternative was selected in 2005. 6 tribes ultimately brought suit, along with some individual tribal members and environmental groups. There's all the plaintiffs listed there. And claims were brought pursuant to the National Environmental Policy Act, RFRA, and the National Historic Preservation Act. So again, I'm going to be focusing in on the religious claims pursuant to RFRA. All right, so there was an 11-day bench trial on the RFRA claims. So you don't have the other RFRA, the NEPA and NHPA claims are record reviews, so you don't get entitled to a trial on those. Those go out on summary judgment. So there was a trial just specific on the RFRA claims at the Prescott Federal Courthouse. And although the tribes lost at the district court, on appeal at the Ninth Circuit with a 3-judge panel, the tribes were successful. The defendants in that case requested a rehearing en banc, so that means for the Ninth Circuit, an 11-judge panel. And Just to give you a little context there, about 1,500 cases are heard every year at the Ninth Circuit and are asked then to be reheard en banc. And about 15 to 25 of those are accepted every year. So really a quite small percentage of cases are accepted to be heard en banc. Unfortunately, this was one of them. And when the case reached the Ninth Circuit en banc panel, the court reversed that panel decision on grounds that the tribes had failed to establish the RFRA violation. The court there held that the sewage water turned to snow did not coerce, there's that word again, the plaintiffs to act contrary to their religious beliefs, nor does it condition a government benefit upon conduct that would violate their religious beliefs as required to establish a substantial burden. So they sort of add this second piece to it. So no coercion or prohibition of your religious beliefs, or conditioning a government benefit on something that would violate your religious beliefs. That's sort of a new definition that they establish in terms of the substantial burden definition. And so there they found that the Forest Service approval didn't constitute that substantial burden because it didn't force that choice between those two tenets or a government benefit or pose a threat of sanction to the tribes. Instead, they held that effectively what the decision did was only decrease the spiritual fulfillment of tribal members. And so what the Ninth Circuit was doing there was effectively narrowing the interpretation of RFRA's language of substantial burden, and did that in referencing the Ling decision. In June of 2009, the Supreme Court declined to hear the case, so denied the certiorari petition, and usually you get those kinds of cases up to the Supreme Court if you show that there's been different circuit courts having different positions, and the Supreme Court then gets to make the final decision on what the law is in the nation. So there were some of those pieces in there, but I guess the Supreme Court didn't think there was enough. So what's happened since that case? Oh, that slide was too much, sorry. One more slide. This was an interesting quote too. So if it were otherwise, again, this kind of harkens back to the Wilson versus Block language. Were it otherwise, any action the federal government were to take, including action on its own land, would be subject to the personalized oversight of millions of citizens. Each citizen would hold an individual veto to prohibit the government action solely because it offends his religious beliefs, sensibilities, or tastes, or fails to satisfy his religious desires. Further, giving one religious sect a veto over the use of public parkland would deprive others of the right to use what is by definition land that belongs to everyone. So going back to that, to Ling, Wilson versus Block, that this is federal land, and no one can have a veto over it. Oh, I had one more. Sorry, I'm behind in my slides. Okay, so what's happened since that case? So the first case I want to mention is Comanche Nation versus United States. That's a 10th Circuit case where the Army was planning to construct a training center in Fort Sill, Oklahoma, and it would block the Comanche Nation's view of Medicine Bluffs, which is a sacred location to the tribe and is listed on the National Register of Historic Places. And in that case, a substantial burden was found to exist. So remember, the test is, first hurdle, plaintiffs have to show a substantial burden. So in this case, the tribes were able to show a substantial burden because they didn't use that Ninth Circuit definition that came out of Navajo Nation. That judge used a different pre-RFRA definition that was authored from a different case out of the 10th Circuit, and that definition was that a governmental action which must significantly inhibit or constrain conduct or expression or deny reasonable opportunities to engage in religious activities would be considered a substantial burden. So under that different definition, more broad, the court found that substantial burden. So having found that substantial burden, Recall the burden flips now to the government. The government has to show a compelling interest. So this was an injunctive case, trying to seek an injunction. And the parties stipped there was a compelling interest to having this training facility. Then the government needed to show then the least restrictive means. The court found that they did not have any evidence that showed that this was the least restrictive means for the government to have this training facility in this exact site, and they entered an injunction. So a different result here. So I do want to talk about, before I talk about Apache Stronghold, I do want time. Okay, 10 more minutes, right? Okay, thanks. I do want to talk about, before we get there, is a case called Burwell versus Hobby Lobby. Anybody ever heard of that one? It's a great case, right? Okay, so those of you that don't know that case, the court held, again, under RFRA. This is not a sacred sites case. This is a case Hobby Lobby brought because they didn't want to provide contraceptions to their employees. So I should note, before I talk about this a little bit more, is that Health and Human Services already had an exemption for religious organizations to not have to provide contraceptive coverage for religious organizations. But Hobby Lobby isn't a religious organization, are they? They're a closely held private corporation, and the court found that they had the religious right, right, under the RFRA. So not even a person, this is a closely held corporation, was found to have the free exercise of religion, and that this would substantially burden them to have to provide contraception protection to their employees. So really quite a broad decision, and I think some of us that do sacred site works were sort of like, well, maybe we could use that moving forward. You know, this is quite a departure from what the court has been saying previously on these types of things. So maybe there's something there. Well, then along comes Apache Stronghold versus United States. So this is the Oak Flat case, for those of you that are familiar with that one. It's a block cave mining project by Resolution Copper Mine that would effectively destroy Oak Flat once the subsidence occurred after the block cave mining, a place sacred to the Apache. And that case went up to the Ninth Circuit just in, I believe the decision came out in July. And basically still said that Navajo Nation was still good law, and that the substantial burden test established there is still the same, and that the plaintiffs there did not go over that substantially burdened hurdle. They did touch on the Hobby Lobby versus Burwell, and they said, no, that's not the appropriate standard here. It's going to continue to be Navajo Nation, Ling, those types of cases. So that's kind of where we stand. And, you know, just a quote there that I've got there from the panel saying that they followed Navajo Nation versus U.S. Forest Service. Basically, who are we to say whether the government action has an objective impact on religious observance or merely diminishes a worshiper's subjective spiritual fulfillment? Questions like these raise issues on which judges must not pass. As we are often reminded, it is outside the judicial knowledge to question the centrality of particular beliefs or practices to a faith. So where are we now? This case, as I said, was decided in July. They filed a petition for rehearing en banc just last week. And so we'll be a few months to decide here whether or not the Ninth Circuit would take that up en banc. They've already said publicly that they plan to take this case to the Supreme Court. So this will certainly be one to watch to see if the Supreme Court thinks there's enough circuit disagreement to take this case up. I think I got a few more minutes, right? 5 more?
5 more, yeah.
Okay. All right, you said that? All right, so I wanted to talk briefly about a couple of other snowball cases or snowball-related cases. First of all, the Save the Peaks Coalition versus U.S. Forest Service. So when I mentioned the Navajo Nation case, there was a number of NEPA allegations brought in that claim, and one of them that the Ninth Circuit found was not properly raised, and so they didn't decide on, was how human ingestion of wastewater, how that would impact, and that under NEPA, they didn't take a hard look at that. And so the Ninth Circuit never made a determination on that particular claim. They said it wasn't properly raised. So the Save the Peaks Coalition attempted to raise that issue, and the court found that the Forest Service had considered that issue. And the final case, sort of, I'd call this a snowball adjacent. It's about the reclaimed water, and Mr. Jocks mentioned this as well, was an action for public nuisance. So it initially sued the city of Flagstaff. They had a third-party indemnification with a Snowball, so the defendant ended up being Snowball. And so this went up to the Supreme Court of Arizona because it was a state claim, and they determined that the tribe's alleged injury from environmental damage to land was different in degree, but not in the kind or quality suffered by the public, and thus the tribe didn't sufficiently allege the required special injury to maintain a claim. So under public nuisance law, you can't have something that everyone's suffering from. It's got to be a special injury in order to maintain that claim. And the Arizona Supreme Court said that the Hopi tribe did not have enough to maintain that claim. So that's where we're at on that. I do want to mention a couple of bills, and I didn't do a slide on this, so I'll say the numbers slowly in case you're interested in. They're actually in committee today, the National Parks, Forests, and Public Lands Subcommittee. Chairman Gahavas has introduced these bills. That's H.R. 8109. That's a Tribal Cultural Areas Protection Act to establish tribal cultural areas, tribal cultural areas system, and H.R. 8108 to protect native cultural sites located on federal land, improve consultation with Indian tribes, and to bring parity to tribes with regard to federal public land management laws and other purposes. So those are in a subcommittee today having a hearing, so it'll be interesting to see if those will move forward. And of course, probably all the tribal folks are familiar with the Chairman Grijalva's Respect Act in terms of improving consultation, having meaningful consultation, and codifying that. So those are some bills to watch in addition to the Apache Stronghold case. And I just wanted to mention, if you are tribal staff or tribal leadership, we have just started a listserv where we don't spam folks frequently, but if we've got your tribal leader letters and there's responsives, for environmental issues, we're doing templates and things like that. So if you want to get on that listserv, you can go to our website there and you can jump on the listserv. That's all. Thanks.